Hello, Josh.
Hello,
Um,
Ryan.
I'd love for you to share about Anodos law. First of all, what are we trying to solve here? What's the problem that is not already sufficiently being provided for?
Well, we've got a demographic problem. We've got 10 million baby boomers that over the next 20 years, almost all of them are going to die. And those baby boomers have assets that need to be settled, need to be transferred to their kids. And that'll either happen through a trust settlement or a probate. And in either case, there are just not enough trust and estates attorneys in California to handle all that work. There's only 5,000 trust and estates currently. And the bummer is about a third of them are themselves baby boomers. So we've got probably two of our highest and best and most experienced practitioners, be they attorneys or paralegals or judges, leaving the practice for every one that comes in. So we've got a big supply demand problem. Everyone knows it. It's hard to get on an attorney's schedule to review a doc or draft a new doc or settle an estate. And what we're trying to do at Anodos Law is anticipate that problem and try to build a practice that's nimble and can serve many more clients than the traditional trust and estates practice. So that's what we're trying to do.
Okay, so you've identified a tremendous need that is present. You also mentioned being able to serve more clients than perhaps some law practices are able to serve, being nimble. What does that mean? How do we do that?
Well, kind of the traditional approach when you have a big demand, which our industry does, is to just add more staff because the service model that our colleagues use is predominantly the service model that they were taught by guys that got their bar cards in the 80s used. So, how you intake clients, how you deliver the service, the cadence that service is delivered over, in many cases doesn't benefit from kind of best practices in project management and developments in technology that have come about over the last 20 years. And so my belief is that we can actually serve many more clients faster without a lot more staff. So I don't think the solution to delivering this increased need is just piling more staff onto the company's employee list. It's thinking about how do we get higher levels of productivity and efficiency out of the existing staff.
Okay, are there ways that you see this service can be um, are there ways that this service can be delivered such that it by narrowing the scope of the service or by narrowing the type of client that the practice accepts, we can do that more effectively?
I think there's a preference amongst our colleagues to work on big, complicated, exciting cases because that's what we were trained to do. That's what we went to law school for, and that's what our training over the last 20 years has been, is to bring best practices in complicated estate tax minimization to the client engagement. So that's kind of the preference. But practically the last 10 years, a lot has changed in estate planning where there aren't that many people that have to pay estate taxes. And so kind of the systems that we've developed are designed to cater to big, complicated, expensive cases when really the vast majority of the 10 million baby boomers have combined net worths between mom and dad of less than 30 million. So they're not paying any estate tax. So many of the elements of our planning practice just aren't needed. So I would say that Anodos focuses on clients with non-taxable estates, estates of $30 million and less, where really the planning is done with an eye towards an efficient settlement rather than minimizing taxes. Because those two things are antithetical. If you want to minimize taxes, it's not going to be an efficient settlement. It's going to be a
Okay.
complicated settlement.
So how would a new client experience engagement with Anodos law differently than a more traditional law practice in terms of um, showing up at a conference table and having multiple meetings and uh, signing parties, and how do they pay? Is
Mm-hmm.
the payment structure different?
Well, uh, we've kind of reverse engineered how would how would my parents prefer to engage with their trust and estates attorney, and have just asked a lot of baby boomers, how's it working for you, and what would you prefer to be different? And one of the first elements of our service offering is that everything's remote. Like clients don't come into our office. That's not even an option, even if they're in Santa Barbara where we practice. We are a 100% remote practice. That does a couple of things. One, it saves the client time engaging with us. It saves us overhead. We don't have to have a big fancy office downtown with floor to ceiling glass and big conference rooms, which allows us to provide the same services at a lower price because we make the same profit because we're paying for not the coolest office in town. So remote is one big element. Um, Another element that's different than what our industry typically does is we exclusively do fixed fee. We don't track hours. I don't want to waste our time with doing that. I don't want there to be surprises for the clients on what they pay. So they get a fee quote at the beginning after we determine what in fact they need after like an intake call, hearing their story and seeing if we can help. And we quote them a fixed fee, and that's what they pay. And if we're really fast, good on us. And if it takes us a lot of time, that's our problem, not the client's problem. We don't get paid more.
Okay, so given the fee structure, which incentivizes us to not bill as many hours as we need to and encourages as many meetings with the client as possible, and because there's not um, in-person meetings that have to be scheduled, how how quickly do these engagements tend to progress and come to completion, do you think, in your experience, versus what a traditional practice might experience? Like, is this a 1 month deal versus what would normally be a 3 month engagement? Is this a 1 week engagement? What have you found?
Well, there's different types of service that trust and estates attorneys do, and I'll say broadly, there are the services that are provided before mom or dad die, and the services that are provided after mom and dad die. After mom and dad die, it's an estate or a trust settlement, which is kind of a long thing, and we'll talk about that later. But on the pre-death planning and service engagements, our objective is to turn around signature ready documents in 7 days. From the time the client signs our engagement, pays our fee online, and has the intake call where we have all their facts, we know what the things are, we review their existing documents if there are any. From that point on, it's like the clock's ticking. And our objective is to get that project completed and hand it off back to the client within 7 days. Now, sometimes that doesn't happen because there's this kind of ping pong match between, hey, here's the draft, and the client says, you got my kid's name spelled wrong. All right, comes back to us, or they rethink about it, or they're on vacation when there's interaction. But our commitment is from the time the client has signed off on everything's ready, I understand the document set that I need. From that time on, I want to get the docs out within a week.
Okay. Okay. You also mentioned there are other services that we provide. So can you be clear about what those particular services are, and perhaps what service Anodos Law does not provide?
Okay, I'll go over kind of the most common ones. The most common service is the trust review and refresh. This is where the drafting attorney did the docs 10 years ago, and the family either knows that something needs to change or just wants someone to review them, and the drafting attorney isn't around anymore because they're a contemporary of mom and dad, so they're 80 something, and they are retired or dead or are priced out of the market for mom and dad's expectations because they're really, really busy. So the review and refresh is interview the client, read the current doc, see if there's any things in the legacy language that ought to be refreshed for best practices. Do those through amendments, which are not tearing up the old document. It's just changing paragraphs or sentences within the document. So that's a pretty fast, very, very common engagement. The next one that's really common is the new document set. This is where the family has known for years they should have done this thing and they haven't done this thing. And they need an estate plan, which includes the trust and a couple of pour over wills and powers of attorney for assets and healthcare directives and HIPAA notices and assignments, kind of the package that goes in the binder that everyone signs. And then you have to put stuff into it. You need a deed to change the house into it. You need to change beneficiaries sometimes. You need to retitle assets. So that's the estate planning package. And then two that come up with some frequency besides those most common engagements are single member LLCs, where the family owns a piece of property or a couple of pieces of property, and for either asset protection reasons or for fractional gifting reasons, they want to set up an LLC, which is then owned by the trust, or doing deeds. We thought the rental house was in the trust. We pulled title on it and found out it wasn't in the trust. Mom and dad have a great trust. They just didn't fund it with all of their assets. So drafting a quick claim deed, the preliminary change of ownership report, all the stuff that the county needs to flip that asset in. Those are the common 7-day turnaround. It's pretty much the same engagement every time, other than the client's facts, and it doesn't take that long to get those completed.
You had also mentioned post-death services, so estate settlement. What does that look like? How do we do that differently than folks might expect from most law practices?
Well, first of all, like 70% of trust and estates attorneys don't do settlements. They focus their practice on what they call planning, which is the stuff before death, drafting the documents. And there's a number of reasons why settlements are disfavored by our colleagues. One is they take a long time. They're a pain in the neck to do. There's a checklist of maybe 50 or 100 stupid things that have to get done. You've got eldest daughter, who's responsible for settling the estate. And sometimes you got younger brothers that are chirping at her, so there can be risk associated with the settlement. So for a lot of reasons, most attorneys don't like getting their hands dirty with the settlement. And I appreciate that that's a generalization. 30% of trust and estates attorneys are totally into it and love doing settlements. And our thesis is that's the real bottleneck over the next 20 years, is that most families name either a family member or a friend, a non-professional, a non-bank, a non-licensed professional fiduciary, somebody that's never done a settlement before is the person responsible for the settlement. And mom and dad chose them because they trust them. They want them to be the successor trustee because they know the assets, they know the family. They're the most responsible of the list of candidates to do the work. But it's flippin' boring work. It's nauseatingly detailed. And that's where the settlement of these baby boomers' estates is going to be a big, big issue, because not a lot of us in the practice do this work, and it's hard work to do, and it's kind of a pain in the neck, and nobody's really automated the process. And so that's kind of the hill that Anodos law was designed to die on. How can we do settlements really, really fast? It should not take a year to do these things. Success should be measured in weeks or months, not years. Fees shouldn't be a surprise. It shouldn't be an hourly thing, which is how almost everyone does it, because we, the attorneys, don't know what kind of tangle of craziness we're going to get into in the settlement. And so to protect ourselves, we just say, look, we're doing it hourly and send me $5,000 as a payment and I'm going to bill against it. And our approach is, look, if we've done 100 of these, we know what the outcome is going to be and what the process is and what the workflow is. We can charge a fixed fee for this. And that aligns financially the beneficiary's incentive and the successor trustee's incentive to get the thing done quick, and our reasonable financial incentive to get the thing done quick, because we want to earn that $5,000 or $10,000 as fast as we can.
Okay, thank you. In closing, what's the do you have a 10 or 15-second line which captures what Anodos law is and how we're different, or how our processes are different from what folks might be most familiar with?
Yeah, our elevator pitch is we deliver trust and estate services for California families. Can't practice outside of California because we don't have a license outside of California. But from Eureka to San Diego, we deliver services for California families twice as fast, at half the cost, 100% remote. And that's what we do. Now, the services that we do, the things I described, reviewing and refreshing documents and writing estate plans and doing settlements and doing deeds, all of those things are exactly the same for all trust and estates attorneys. I mean, that's the product. Whether you go into a huge practice down in LA, or whether you go into a little solo practitioner in Kern County, the work product is the same. And what we're trying to innovate is how that work product is delivered and paid for. But it's the same outcome. It's the same blocking and tackling. Twice as fast, half the cost, 100% remote.
Good. Thank you, Josh.
Thank you, Ryan. See y'all.